Good morning, everyone, and thank you for joining us. I hope you're all doing well. So while the circumstances that bring us together for this discussion are certainly unfortunate, I do appreciate you taking the time. So for those of you who haven't joined us for other webinars or unfamiliar with PROXUS, my name is Matt Roessler. I'm Director of Business Development, dedicated to supporting our legal community, clients, and contacts with payroll and HR technology needs. So PROXUS is proud to have many of our area's top law firms as clients, and I'm pleased to see that we have several on the line with us today. I'm also pleased to be joined by Mike Torchia, Managing Member of Semanoff Ormsby Greenberg Torchia. Mike has certainly been a longtime friend of PROXUS and certainly several of our clients as well, providing not only legal advice, but hosting past education sessions for our team and others. Mike recently presented to the Independence chapter of the ALA on employment law issues for law firms and appeared on Channel 10 News related to COVID-19. As issues continue to evolve with COVID-19, Mike has been at the forefront of the impact on organizations and their employees. As managing member of his firm, Mike brings a unique perspective and dialogue around how law firms are managing things like FFCRA, the new CARES Act, and remote employees. With the fluid nature of events, we'll be keeping today's discussion as primarily that, just a discussion. We will not be sharing slides, rather Mike will be speaking to you about the topics mentioned a moment ago. I encourage you to submit questions as we go using the attendee panel that you have there in front of you, and we will answer those questions either during or at the end of the presentation. So we'll be recording today's session as well, and all attendees will be muted to avoid any background noise. With that, Mike, I turn things over to you.
All right. Hello, everyone. I suspect that some of you I met before when I was out there in person making a presentation. Glad you could join us again today. So, as Matt said, as someone who is running a law firm, we have just had, it seems like, every issue possible in the last month, 5 weeks about what to do with working remotely, how to handle this Families First Act, how to handle the CARES Act, and then many issues around unemployment, and how do we treat our lawyers, and how do we treat our paralegals, and how do we treat our staff. So I'm going to try to hit a variety of these issues and then hopefully give you a chance to ask some questions later, as Matt said. So we're going to jump around a little bit, but primarily I'm going to divide my talk into 3 parts. The first part are going to be just some, what I'll call just some quick miscellaneous issues surrounding law firms, particular to law firms and the issues that are happening now. The second part is I'll talk about the Families First Act, which I think is of particular interest to law firm administrators and people who run law firms. And then I'll mention CARES, although I'm not sure how much of the audience today is really getting into applying for loans and some of the other CARES provisions, but we'll talk about that, especially how it affects your employees. One big issue to keep in mind is that not all of these provisions apply to all businesses of all sizes. Most of what we're going to talk about today apply to businesses of 500 employees or less. So that would be, I think, most of the people on this call, if not everyone on the call. But just keep that in mind. And when size matters of the employees, I'll try to remember to talk about that, so that you can, figure out whether this applies to you or not. So let's start off with just a couple of particular items for law firms and what you're seeing. First of all, can law firms operate? Can we even be in business these days? And I'm sure you know by now, you've seen the governor's orders, you've seen the chart, maybe you've seen the chart of the quote unquote life-sustaining businesses. There was an initial chart that went into effect within hours, and then there was another chart, and now there's a third chart. And the third chart has been more specific about some industries, and some other industries have not changed at all. But law firms are not considered a life-sustaining business generally, although the Pennsylvania Supreme Court has said that we meaning all of us on this call, law firm staff and attorneys, should operate to make sure that our clients' constitutional rights are not violated. And we can also operate to the extent that we need to do necessary services for the clients and even for the law firm. So I think what most law firms are doing is we're working remotely, everyone's home, and some people are stopping in, to make sure the building didn't burn down, and maybe to get the mail, open up important pieces of mail, maybe get billing and those sorts of things. So as long as that social distancing is honored, that's what most people are doing, and that is not considered to be in violation of the governor's order. But doesn't mean we can all go back to work, certainly, at least not in most of the law firms that that we normally deal with. One interesting aspect, and some of your attorneys might already know this, but we have just received a flood of emails from all of the different court systems about how they are treating the courthouses, whether you can go to the courthouse, whether you can file, whether you can file electronically or in person. What do you do about hearings? What do you do about depositions? And most importantly, to me, what do you do about deadlines? Lots of the courts have said, hey, all of our deadlines are expanded or extended 30 days or 15 days or until the end of April or whatever it is. So if the lawyers are not looking at the announcements for every particular court that they might have cases in, then they should be, because there's no uniformity among some of the courts about the extension of deadlines. Managing telework, working remotely. And this gets into whether your folks are exempt or non-exempt employees. So just a quick reminder, I think we all know that non-exempt employees under the Fair Labor Standards Act are sometimes, people call them hourly employees. They are eligible for overtime. Exempt employees are not eligible for overtime. So if you have people working remotely, whatever time they work, you need to pay them for. Non-exempt employees, you need to pay the non-exempt employees. If they work an hour, they get paid an hour. You can certainly pay them more than that, of course. You can always be more generous, but that's the general rule. And if by some chance they work more than 40 hours, they're still eligible for overtime. So that hasn't changed. The exempt employees are tricky. And the exempt employees, for those of us who are not eligible for overtime, the general rule is that if an exempt employee works any part of a work week, Monday from 9 to 11 in the morning, and then doesn't work the rest of the week because maybe there's no work to do, they're supposed to get paid for the work week, for the whole week. Now, there are some exceptions to that. If they're on FMLA leave, if they've been terminated, if they take time off for personal reasons. But if there's just no work for them to do and they work any part of the week, they're supposed to get paid for the entire work week. That's not new. That's not coronavirus rules. Those are just regular rules. So that's something to keep in mind when you're talking about whether or not to pay people. That does not mean that they have to get their full salary, what they were getting before. You can cut people's pay. You can say, okay, you're going to get paid for the week, but all of the attorneys now are going to be paid, 2/3 the salary, or going to cut you by 10%, or whatever it is. That's okay. You can do that. But you can't not pay them for the week. Hold on 1 second for me, if you would. Thank you. I had something making some noise in my home office here. So again, that's the exempt and non-exempt. And just a reminder that paralegals are exempt employees. There was some question about that years ago, and the Department of Labor came out and said, okay, we're just going to resolve this, and paralegals are, I'm sorry, listen to me. Paralegals are non-exempt employees. They're eligible for overtime. So they are hourly workers. They are non-exempt. They are eligible for overtime, generally, paralegals. Yeah.
Quick question around that. When you talk about reducing an exempt employee's salary, is that across the board? Can you choose certain groups of exempt employees to reduce, or should it be, again, across the board if you're going to do that?
Right. So it does not have to be across the board. You can pick and choose employees to do that. You can say basically whatever you want. You can say this group or we're going to do it for everyone for a week or 2 weeks, or we're going to rotate and it's going to be you 1 week and you the next week. Or you can just say, hey, Shirley, and for those of you who've heard me speak before, Shirley is my fictitious employee. You can say, hey, Shirley, you're going to be reduced. Now, of course, if you start picking and choosing people, no one is going to question the need, I think, to reduce salaries in this environment, but they might question, why me? Shirley might say, why me? Why not her? Or why not him? And you should have a reason for that. You should have a good reason for, why Shirley and not someone else. As always, make sure you're not picking on just, the women, or you're not picking on the older workers, or you're not picking on, or making changes to, a certain class that might make it look like it's discriminatory. Sure. But you can pick and choose.
Thanks.
We've had questions about health insurance. What happens if we reduce people, or we lay people off, or we furlough them? What about health insurance? And the answer is that the general rule, again, is that if someone's hours are reduced below what is eligibility at your firm, so let's say eligibility is 30 hours and they're eligible for benefits. If they fall below that line, they should be getting a COBRA form, a COBRA election form, a letter that says you can continue on COBRA, if you wish, with your health benefits. Now, a couple of things about that. First of all, many of the providers have said that they are not going to drop employees from the health benefits, even if their hours reduce below the eligibility, and even if they're no longer employed, even if they get laid off. As long as they keep receiving the premiums, then they won't get dropped. So you have to still make the monthly payments, and people below the eligibility hours and people below, even if they're laid off, should not be dropped. Now you have to check with your provider. I don't know if that's every provider, but I know that many of the major ones, including Blue Cross, have done that. The second thing is, when we talk about COBRA letters and COBRA election forms, that only applies to businesses with 20 employees or more. So federal COBRA applies to businesses with 20 employees or more. If you're under 20, you're not subject to federal COBRA, but you are subject to, Pennsylvania State has a COBRA program. Some people call it mini COBRA. And what you should do is notify your healthcare provider that someone's been laid off or their hours are reduced, and your healthcare provider will more than likely send them a notice. So health insurance has been a little bit easier because the providers are not dropping people, which is a good thing.
Mike, one thing related to that, kind of on the technology side, and I know we've got a mix of both clients and non-clients on the line. But for those of you who may have a benefits administration system built into your HCM platform, so your payroll and your ben admin are joined, just be careful in terms of a status that you may put your employees in. So for example, if you're putting somebody on a terminated or an inactive or a furlough status, on the back end of your system, it's very likely that may or may not kick off automatically a COBRA notice. So if you don't want that COBRA notice to go out, as Mike is saying, talk to your carriers, talk to your brokers, talk to your insurers, make sure you're talking to your technology folks as well, so that things can be recoded if necessary to either kick off or not kick off that COBRA notice, depending on the circumstances. Just something that we've been seeing.
Which is a perfect segue into one more or two more topics on the miscellaneous before we get into the families first. We're starting off slowly before we get to the Families First Act, where you start to get a migraine after that. All right, so two more things. One is that what Matt was saying, the status of people. We get lots of questions about furloughs. Hey, what's a furlough? And what does that mean if we put people on a furlough? And how do we know? And do we tell them it's a furlough and all this stuff? I've never heard the word furlough so often in the last 3 weeks. So a furlough is not is not a creation of law. You can't look at a statute and say, here's a definition of a furlough. Most of the time, including in our, kind of crazy period right now that we're all in, there are a couple of terms that have certain meanings. So for example, a reduction of hours usually means that an employee is still working for you, they're still putting in hours, but they've just been reduced. Kind of makes sense, reduction of hours. A layoff, in kind of common parlance, is someone is no longer an employee. They're terminated from the firm and they're no longer an employee. They're separated. And that's because usually it implies that there's a lack of work. So a layoff, and some people call it a reduction in force or a RIF, RIF. Those people are no longer employees, and maybe they'll come back, but that's kind of the common usage. A furlough applies to or refers to something that's in the middle. Someone is not working. In other words, there are no hours for them to work, but they're still an employee. They're just dormant. And you can be furloughed for a week, you could be furloughed for a month, you could be furloughed indefinitely, but they're still employees. So they have all the benefits of being an employee, they're just not working or they're just not getting hours. If you have people who are furloughed, then just make sure of a couple of things. If they're hourly, make sure they're not putting time in. Because if someone's furloughed and you say to them, we don't have any hours for you to work, but you're still asking them, check email, answer phone calls. Hey, I have a couple quick questions for you. Hey, the billing came out. I know you're furloughed, but can you just check these bills? If they're hourly, that's all work that they should be paid for, even though they're furloughed. And they might earn a couple of hours if that's what they're doing. Exempt employees, that gets, again, I don't think people are doing this, but technically, if an exempt employee does any work in that work week, if you have an attorney who's supposed to be furloughed and she does any work in that week, she's supposed to get paid for the week, which is, again, not the intent. What a lot of firms are doing is they're essentially treating exempt employees like non-exempt. They're saying, we don't have a lot of work, so we'll pay you for what you do. We'll pay you for the days you're coming in, or we'll pay you for the hours that you bill. Not really allowed, under the Fair Labor Standards Act. Again, I know lots of firms are doing that. I don't know what the result's going to be. Maybe nothing. Maybe the exempt employees are fine with that to get anything. But again, that's not something that's normally allowed, is to treat exempt employees like non-exempt or vice versa. So, and then the last thing in this little miscellaneous part is, for attorneys, their compliance period with continuing legal education with CLE credits has been extended. So the next compliance period, which would end on April 30th, in a couple of weeks or whatever, is now extended to end August 31st. So how many days in August? 30 days, 31 days in August. I have to do the poem. 30 days, yeah, 30. Anyway, the last day of August. So if the attorneys are scrambling to get CLE credits done, there's only a certain number of credits that they can do online. I think it only might be 6. And then, but it has been extended to August. So you may want to know that for your folks who are trying to get CLE credits. Let's see. All right, I think that's it for kind of the quick hits. So let's talk about the Families First Act. This is, I'm going to refer to it as the Families First Act, or the FFCRA. This is the Families First Coronavirus Response Act, FFCRA. And it has a couple of different pieces to it, which affect businesses of all sizes, no matter how big you are. And it could potentially affect your employees and whether or not they get emergency paid sick leave or they get family medical leave. Even if you're not subject to the Family Medical Leave Act right now, you may be subject to the FMLA because of the FFCRA. So the Families First Act was enacted into law, and it went into effect on April 1st. So start with that. Nothing you did before April 1st matters when it comes to the Families First Act. So if you provided people with vacation or PTO or whatever you did with their salaries or whatever you did with, leave, paid, unpaid, whatever it is, prior to April 1st, doesn't matter. You start with April 1. There are two sections, and I'll talk about them separately, but let me just tell you how they interact. The first section is the Emergency Paid Sick Leave Act. So it's emergency paid, that's the important part, right? Paid, the Emergency Paid Sick Leave Act. That's for a maximum of 2 weeks, 2-week max. The second part is the FMLA expansion. It's the regular FMLA federal statute, but it's been expanded to give additional benefits. The way it works is that if someone needs to go on leave, the Paid Sick Leave Act starts with the Family Medical Leave Act. They both start the same day, but the first 2 weeks of the FMLA are unpaid. So what they did is they joined the two parts and they said, if the Emergency Sick Leave Act will be 2 weeks, the FMLA expansion will be an additional, is 12 weeks, but the first 2 are unpaid. So an additional 10 weeks. So it's 2 and 10. 2 under the Emergency Paid Sick Leave Act and potentially 10 extra weeks for FMLA. So someone could theoretically get emergency benefits for up to 12 weeks. But let's talk about the reasons for that. So the Emergency Paid Sick Leave Act first, which is the more complicated one. FMLA is actually easy. The Emergency Paid Sick Leave Act says that an employee who is eligible can earn these benefits for up to 2 weeks. There are 6 reasons why someone can be eligible for emergency paid sick leave. 3 of the reasons are for someone taking care of themselves, and 3 of the reasons are for someone taking care, one of your employees taking care of someone else. So the first 3 reasons are that someone can't work because of an isolation order, a quarantine or isolation order. And then the second reason is someone has been ordered to quarantine by a healthcare provider. Not if they choose to themselves, and not if you send them home, but a doctor, healthcare provider says you need to be quarantined. And then the third reason is they're suffering from symptoms, or they suspect they have COVID-19, and they're waiting for treatment, and they can't work because they're waiting for treatment. So it's quarantine or isolation order, doctor told them to quarantine themselves, or they don't know and they're getting treatment and they're waiting for test results, and that causes them not to work. The key here is that if someone is sent home because there's no work to do, your firm has slowed down, or maybe their practice area has slowed down, or you have staff and you don't need that many staff, or whatever it is. If there's no work to do, you don't even have to have the discussion about the Emergency Paid Sick Leave Act, right? So if there's no work to do, if they're laid off or they're furloughed, then you don't have to worry about giving them benefits under the Emergency Paid Sick Leave Act. They only get benefits if the reason they are not working is because of one of these. Let's just take the first 3 reasons. So someone says, for example, hey, my doctor told me to quarantine. And you might say, okay, that's fine, but you've been laid off, or you've been furloughed for 2 weeks, for 3 weeks. Even if your doctor wasn't quarantining you, there's no work for you to do. That person is not eligible for benefits. The only way they're eligible for benefits is if you're asking them to work, There's work for them to do. You're asking them to work, and they would otherwise work, but they cannot because of one of these three reasons. And by the way, even if someone's quarantined, that doesn't mean they can't work. You know, I mean, I'm sitting here in my home office right now. If I was quarantined, frankly, I don't know it would be that much different from what I'm doing right now. You know, I mean, if I had symptoms and I was in bed with 104 fever, like, okay, fine. But if a doctor said to me, hey, Mike, you were exposed to someone and you need to quarantine, I would say, okay, I don't know what I would be doing much differently. So it's not only that the firm is asking you to work and you're saying you can't, but you have to actually not be able to work. So not everyone who's quarantined is restricted from working remotely. And that's what's confusing a lot of people. We're having employees walk in and say, well, look, I've been told to quarantine, so I get the benefits. It's like, no, you know, there's no work for you to do anyway. If someone does qualify, though, you're asking them to work and they can't work because of one of these reasons, then they get paid their regular rate per day, capped at $511 a day, up to 10 days. So if someone is making $450 a day, they get $450. If someone's making $650 a day, they get $511. It's capped at $511. And the longest they can get it is for 10 days. So, you know, 511 times 10, it's $5,110 is the most they can get under the emergency paid sick leave part of it. A quarantine or isolation order, reason number one, is a little complicated. What Governor Wolf has said to us, a stay-at-home order, is considered to be a quarantine or isolation order. And right before we went on this call, I was telling Matt, you know, that we were giving advice a few weeks ago when this first came out, and a quarantine or isolation order was not considered to be what Governor Wolf put out. And now there's been all sorts of guidance from the Department of Labor. They put out two additional guidance papers, including one that's 59 questions and answers, and another one that's 124 pages of just a narrative explaining, you know, answers to questions that people have been asking. So anyway, one of the things they clarified is a stay-at-home order is considered an isolation order, but that does not mean that if your people are home, like we all are, they get the benefits of this. Once again, first of all, you have to be asking them to do work, and then they have to be unable to do it because of the quarantine or isolation order. And the circumstances of that are so narrow that it almost never applies. In fact, the Department of Labor gave an example and said, just because you're under a quarantine or isolation order doesn't mean you get these benefits. You have to be asked to work, you have to be under a quarantine or isolation order, which means, I mean, first of all, if you work for a business that's a life-sustaining business, you're not even subject to it, you can go to work. But law firms are not life-sustaining, okay, fine. So they gave an example of when it would apply. And the example they came up with was, now here we go, get ready for this, a power outage. They said, if you're under a stay-at-home order, if you're being asked to work and you're under an isolation order, the only way you have to be able to not work because of something that's happening at home that doesn't allow you to work, like a power outage. Okay, you know, great example, I guess, but I mean, how long is a power outage going to last? An hour, 2 hours, a day? You know, I don't know. I guess if an employee did not have internet access, that might qualify. I guess if an employee did not have a computer and that stopped her from working from home, I mean, presumably, you know, you wouldn't buy her one or loan her one or whatever, maybe that. So my point is, if you read the Families First Act and you read that first reason, and some of you I think have read it, and you see that first one, oh, quarantine or isolation order, you might think, oh, this applies to all of our people. You know, they're all going to get these benefits. Not so, not by a long shot. So those are the reasons for the self-care. The second three reasons are essentially the same, except it's for taking care of other people. So if someone's taking care of a child because they're not in school, and no kids are in school, or because the daycare not running anymore, or they lost their daycare person, whatever it is, or they're taking care of a family member related to COVID-19, then they would get benefits. But once again, I want to keep repeating this because this is like one of the most frequent questions we get. They have to be asked to work, and then they have to say, I'd love to work, but I can't because I'm taking care of my child, or I'm taking care of my mother. If that's true, then they get, this is a different number. This is a different formula than the self-care. The self-care was regular rate capped at $511. For taking care of others, it's 2/3 of their regular rate, 2/3 of the regular rate, capped at $200 a day. So it's 2/3 of the regular rate, capped at $200 a day for up to 2 weeks. So they would get a maximum of $2,000 under the we're still under the emergency paid sick leave act part of this, the 2 weeks. So now what's very important to realize about this whole emergency paid sick leave act is you, the law firm, are not ultimately paying it. You're paying the employees. Let's say you have to pay someone the $200 a day, and you pay $2,000 in the first 2 weeks. That has to come out of your bank account, but you pay yourself back. How do you do that? Federal government. You pay yourself back because as you make payroll to your people, as everyone knows, you have withholdings. You have to withhold a certain amount for Social Security taxes, for other withholdings. You still make those withholdings, but instead of withholding that amount and paying it over to the government, you keep it, you retain it to the extent that you made these payments. So if you paid one of your employees $2,000, you keep the withholdings to the extent of the $2,000. Now, how that happens, I don't know, Matt, maybe you know, mechanically how that happens, what your payroll people have to do to make that work, and the codes and this and that and keeping track of it, I can't help you with that. But that's the mechanism. You make the payments under the Paid Sick Leave Act, and you essentially reimburse yourself to the extent of that.
Excuse me. Quick sneeze there. So yeah, Mike, you're right. It goes back to just like we were talking about with the different status codes, right? So most of the providers at this point have put into place different earnings codes, right? So whether it's COVID-19 sick, COVID-19 expanded FMLA, and those codes have certain taxability tied to them. So just like if you've got somebody on active, terminated, furlough, that's going to potentially affect the benefits administration side of this. The earnings code that you use for any compensation to employees, whether again it's COVID something or whatever the moniker is that your payroll provider has built into the system, that's going to have those different taxability codes attached to them. Hopefully your provider has been in contact with you, explain that to you, but if not, that's definitely a call you're going to want to make sooner than later if you do have employees that are going out and being paid underneath any of these new acts, because that will again affect your ability to be reimbursed.
So two more things on this part before we talk about the FMLA, and I promise FMLA is easier. So two more things. One very, very frequent question that we were getting, which we were not able to answer entirely until we got the 59 question and answers and 124 pages from the Department of Labor. One question is, can this be intermittent? Does it have to be all or nothing? Does someone have to, have to be completely out or completely in? Can they, for example, can they take care of a family member for Monday, Wednesday, and then work Tuesday, Thursday, Friday? The answer is yes, that it can be intermittent leave. It can be partial leave. And if there is partial leave, then you would just prorate everything. I mean, you don't have to actually really prorate it, because if someone is taking care of their mother on Monday and they qualify, and they're taking care of their mother on Wednesday and they qualify, they're going to get their regular, well, they're going to get the 2/3 of their regular rate on the Tuesday and the Thursday and the Friday. They're just going to get, the benefits for whatever time. I'm sorry, they're going to get the benefits for the Monday and Wednesday that they're out. And then they're going to get regular pay for whatever they work, the Tuesday, Thursday, Friday. So it can be taken in part, in sections. We haven't actually seen any guidance one way or the other that would prevent you from doing it half days. Like, why can't you do it in the mornings and then in the afternoon they're back at work? Okay, we have seen no restriction on that. I mean, putting aside that it's a pain in the neck to keep track of, but other than that, legally we haven't seen any exemption from that. One big issue is a small employer, whether small employers are subject to this. Now, this was a huge issue when the statute first came out. They said, well, small employers under 50 might be exempt from these provisions, but we'll leave it up to the Department of Labor to let you know, basically. And they didn't let anyone know until just a couple of days before it went into effect, which led us all. So we had, multiple webinars and multiple emails and multiple phone calls where we said to a lot of our small employers under 50, you have to do all these things. We haven't heard from the Department of Labor yet. You have to do these when it goes into effect. So the Department of Labor did come out with an explanation and clarification, but it's not what everyone thought. Everyone thought that they would say, anyone under 50, don't worry about any of this. That's not what they said. What they said is that if you are under 50, and the reason, by the way, some of you know that 50 is the cutoff is because under the Family Medical Leave Act, the regular Family Medical Leave Act, that's the cutoff. If you don't have 50 employees, you don't have to worry about it. The Department of Labor said small businesses under 50 can be exempt from one part of this. And then they're only exempt if they can demonstrate certain things. The one part that they're exempt from is the child care provisions, taking care of a child. So if someone says, I get emergency paid sick leave because I have to take care of my child, if you're a small business under 50, you could be exempt from that. That could be an exception where you don't have to pay them. Even though you're not really paying them, you're going to get that back. You still don't have to give them those benefits if you're a small business. But you need to demonstrate, and I can send the language, Matt, I can maybe send this language. If people need it, I can send it. It's right in the regulations, but it might be easier if I, maybe after this webinar, if I forward it to everybody.
Sure.
But you basically have to, say or be able to state in good faith that one of three conditions applies. And I won't read every word of the condition. I don't remember every word of the condition, but basically it's, you have to demonstrate that your financial situation just doesn't support paying someone these benefits. You can't afford it, basically. That's the first reason. The second reason is that the employees, that it would put the same, basically it all comes down to it's gonna destroy your firm, or has a chance of destroying your firm. The first one has to do with pay. The second one has to do with this employee being out of work because of childcare would allow you not to be able to carry on your operations. And the third one is you don't have other employees that are able to fill in and do it. Not every law firm can say that. That's tough to say that. If I have to pay this person $1,000 this week, that's gonna jeopardize the financial health of the firm. Maybe in this environment, maybe it could, but that seems to us to be a tough standard. You don't apply anywhere. You don't have to apply. You don't send this into the government. You don't send it into the Department of Labor. What you do is you just say to your employee, no, and this is why. And then if your employee challenges it, or it comes to be an issue, hopefully you're right. Hopefully you're right at the end of the day. And if you're not right, then you would end up paying them. But again, you'd end up paying them, but you get it back anyway. So, so I can't tell you what most firms are doing. I can tell you that we represent some law firms that don't have, you know, employment lawyers. I can tell you that they're kind of erring on the side of caution, and if they're financially able to do it, they're providing the benefits. All right, so that's all emergency paid sick leave. Expanded family medical. I promised it would be simpler. Here's the thing about expanded family medical leave. There's only one reason why someone can get the extra 10 weeks of benefits. That's because they're taking care of a child. It's because of childcare. Not even taking care of family members. But if they are out because of childcare, that's the one reason that the government has expanded the FMLA and made it paid. Because again, those of you who deal with FMLA know that FMLA is up to 12 weeks, but it's unpaid. You don't get paid under the FMLA. You know, you can use your PTO and whatever else, but it's unpaid. So people get paid now under the expanded FMLA only if they have to take care of a child. And once again, only if that child care prevents them from working. So if someone has a 17-year-old at home, it's for kids under 18. If someone has a 17-year-old at home and they say, well, I can't work, I have a 17-year-old at home. You might say, really? You know, my 17-year-old doesn't want to even see me in the day, you know, down in the basement. And you can ask questions. You can ask all those questions like, why? Like, you know, what do you mean? What are you doing? Now, if they're saying, well, I'm tutoring and I'm teaching and I'm doing these things, okay. I mean, obviously special needs kids, you know, situations like that. But it might be a little suspect if someone says, I have a teenager and I can't work, you know, 5 days because I need to take care of my teenager. Yeah, maybe a couple hours a day, but maybe not all the time. So you are allowed to ask questions. Unfortunately, there's no good form for that. Lots of people are asking about forms. Well, what, you know, if you're out because you're sick, we know that there are FMLA forms, there's doctor certifications, but for childcare, it's not really good forms. You can get an employee to certify that that's what it is. You can ask for the name of the daycare center to make sure that they're really shut down, although we all know that they're all shut down, you know, at the moment. But the point is, FMLA is only that one reason, and that one reason is childcare. If you're exempt as a small business, if you meet one of those factors, then you're also exempt for the FMLA portion. So, so the point is, the only way that someone's even in the running to get 12 weeks is if it's childcare. If you're a small employer, you might be exempted from that. And then once again, you're only paying these people, and you get it back, even the FMLA portion. You're only paying these people to the extent that the child care does not allow them to work, assuming that you're actually asking them to work. So.
Hey, Mike, let me interject right there real quick. We have a question that came in that's related. So, you know, as you mentioned, for sick leave, you have to have work for them to do, right? For this employee to do for them, and they have to not be able to do that work for them to get the pay. With the child care, you know, if they have an employee who they've told that they can work their own schedule, right? So work around the child care, work whenever you need to work, take care of your child whenever you need to take care of your child. Can the employee still opt not to work and take that benefit? You know, essentially, is it the employee's choice, or who dictates this?
No, it's not their choice. If you've made an agreement with someone and you said, hey, we need you to put in I don't know, you know, 15 hours this week. Everyone's kind of reduced. We need you to put in 15 hours. You can put them in any time. And the employee says, well, I have childcare responsibilities in the morning. Okay, you know, do you have 15 hours to work the rest of the time? Yeah, sure. And then the employee comes back and says, yeah, but I don't want to. You know, I'd rather take my benefits and not do it. No. If you're asking them to work and they're able to work, then, you know, they just can't opt to do it. Now, but you do raise another issue though that I forgot to mention, which is, and this is a frequently asked question by administrators, can you force them to take PTO and vacation and sick and all of that before they get the emergency paid sick leave? And the answer is no, you cannot. You cannot force them. It's the employee's choice whether it's the employee's choice whether they want to take that or not. But if the employee can choose to get the emergency paid sick leave time first, and then take their PTO or their vacation or whatever, or save it or whatever they do. And Matt, back to your question, or the question someone else asked, can the employee choose? The intermittent leave portion of it, is, like I said, the employee can't choose. Stated differently, the employer has to agree. The employer has to agree with the intermittent leave, which is different than the regular FMLA, where in the regular FMLA, the employee essentially has rights, the right to get intermittent leave if they qualify for it. But this is flipped around a little bit. As a matter of fact, those two issues I just said are completely flipped around. So in the regular FMLA, the employee has the right for intermittent leave. Under the expanded FMLA, what we're talking about now, it's the employer's choice. And on the PTO vacation, under the regular FMLA, the employer can force the employee, can mandate that they take that leave before they get FMLA time, or before they get the unpaid, I should say. But under the expansion, the employer cannot. The employee gets to choose. All right, I'm going to talk about the CARES Act a little bit, and there's other things to talk about with the FFCRA, but let me just move on to the CARES Act. The CARES Act is really complicated. I mean, super complicated. This thing went into effect on March 27th, and we were getting calls. I was getting calls from clients. March 27th was what, a Friday? I was getting emails from people on a Saturday and said, "Can we talk, later today about how the CARES Act interacts with the FFCRA, and what about layoffs and what about unemployment?" And I was telling people, you have to give us a chance to read it. The thing is, the CARES Act was, I think the original was what, 884 pages. There was a lot of information that went out. You probably have received some of it, a lot of summaries and a lot of, kind of a boiled down version of it. And some of them are good, some of them are not so good. Some of them are just not accurate. And to make matters worse, if you're looking at a summary that you received, right after this went into effect, I wouldn't rely on it. They, once again, just like the FFCRA, there have been clarifications, there have been further guidance. They actually changed some of the provisions. So let me just talk about a couple of the employee issues, and then I'll just mention the loan provisions. I don't know how much people are getting into the loan provisions, but you should know about it. So first of all, for what we all care about, probably mostly, administrators, HR folks, the CARES Act supercharged unemployment, right? So the CARES Act said we're going to give X number of hundreds of millions of dollars to the states, and anyone who qualifies for unemployment with the state is going to receive, in addition to whatever they receive, $600 a week. And that's going to last until July, end of July. So if someone qualifies for unemployment, they can get unemployment benefits, whatever they're going to get, whether they're laid off or whether there's a reduction in hours, because you don't have to be unemployed to get unemployment benefits. You can apply if your hours have been reduced. You're going to get whatever you qualify for, and then $600 on top of that per week. That's the first thing. The second thing is the regular unemployment period has been expanded by 13 weeks. So in Pennsylvania, the regular unemployment period is 26 weeks. So that's been expanded to 39 weeks. That's the same thing that the federal government did back in 2008, 2009 financial crisis. The third thing they did, and I don't remember this from I certainly don't remember the $600 from the financial crisis. I don't remember this as well. The third thing they did is they expanded the universe of people, of workers, who are able to take advantage of unemployment. So some of you may have this experience. Someone applies for unemployment. The first thing we say is, were they an employee? You know, if they were an independent contractor or something, then you don't qualify. Well, now unemployment has been expanded to almost anyone working for your firm. Full-time employees, part-time employees, independent contractors, people who are self-employed, which might include the owners of your firm, equity owners of your firm, people who are sole proprietors, and seemingly almost anyone can apply for unemployment. Now, obviously, you have to have your hours reduced to apply or be laid off to qualify for unemployment. But in terms of who may apply, it's almost everyone. As a practical matter, I've heard, and I haven't done this myself, but I've heard that when you go onto the website, that if you are one of these people that doesn't otherwise qualify, like you're an owner, you're an independent contractor or whatever, you would not normally qualify for unemployment benefits. At least in Pennsylvania, I've heard that they're redirecting you to some other site or some other place where you apply. I also have not heard yet that people are actually receiving the $600. That's money that the state is not paying. It's money that they're paying, but they're supposed to get reimbursed from the federal government. So I don't know the mechanics of that, if they're getting the $600. But what's interesting, if you start doing the math, you could have employees who, between what they're getting from the reduced hours or unemployment or layoff and the $600, are making more money than they would have if they were working. And that's right. I mean, that's not a mistake. Congress, when they were debating this came up before the statute was passed. So you could be getting people who are opting to be on unemployment or saying, hey, lay me off. I'd rather collect the unemployment rather than working. And we're getting all sorts of questions about, well, what about that? What if we have work for someone and they say, we don't want to work, we want to collect unemployment? No. If you have work for them and you're asking them to work and they're saying, I'm not working, well, then they quit. As far as I'm concerned, they resign, they quit. Whether they would still get unemployment benefits, they shouldn't, but they might. And this gets a little complicated because people say, well, I know you want me to come in to work, or I know you want me to do this, I know you want me to do that, but I'm afraid. I'm afraid to come in. I don't want to contract the disease. I don't want to go out there. I might have an underlying condition, whatever. And the employer says, hey, look, I hear you, but this is just like a snowstorm. We're open during a snowstorm. If you don't want to drive in the snow because you're afraid, this is the same situation. If you don't want to come out because you're afraid, that's on you. Maybe. I mean, you could let them go, but what happens with unemployment, I don't know. Because again, those of you who have had experience with this, if you're terminated, you get benefits unless you've done something that's, willful misconduct. If you quit, you don't get benefits unless you do something, unless the reason you quit was something they call, quote, necessitous and compelling. So, easy example, a woman is sexually harassed at work. She quits because of it. She would almost certainly get benefits because she quit for a necessitous and compelling reason. That's a good reason not to be in the workplace. Is the fear of contracting COVID-19 a necessitous and compelling reason? I don't know. I don't know what the job center is going to do with that. They might say yes. They might say, we understand you're an older worker, you have an underlying condition, that was reasonable. Or they might say, you're a younger worker, you're 20 years old, you have no underlying conditions, that was not reasonable for you to go in, that wasn't necessary. I don't know. So that remains to be seen. Another aspect of the CARES Act is that employees can borrow from the retirement plan. I'll just mention that just so you know that's out there, but that's a benefit possibly to give to your employees, that they're allowed, I think it's up to $100,000 from the retirement plan. And there are some details about how that gets paid back. There are no penalties on that, but how that gets paid back. But that's a way to get money into your employees' pockets if they've been reduced or they've been laid off.
So Mike, we've got about 5 minutes left. I do have 1 or 2 questions back related to the FFCRA, but anything else that you wanted to hit real quick related to CARES Act?
Yeah, I'll go 30 seconds and then I'll stop and get the question. And by the way, I know this is for an hour. I mean, I'm happy to spend a couple minutes, after if that works in people's worlds. But so real quick, on the health benefits issue, this is not a CARES Act provision. Just I want you to know about it. I mentioned some of the providers are not dropping people from the benefits. Blue Cross is also letting you defer health premium payments for either April or May. For April, I think you have to get it's a short little application it's April 17th, I think is the deadline, and then May 17th. What that means is that, like, our firm is doing this. We haven't done it yet. We're not going to pay healthcare premiums for May, and it's deferred and split up 3 months, August, September, October. So the people on our health plan will have a little more money in their pocket next month, and they'll have to pay it August, September, October. But that's, again, another way of getting a couple dollars into your people's pockets. And then the last thing I'll mention under CARES, and we'll get some questions on FFCRA. The CARES Act has a variety of SBA loan programs, way too complicated and long to get into right now. But one of the things you might want to, if your firm doesn't know about it, is called the PPP, the Paycheck Protection Program. And if you ask anyone about PPP, if you ask your bank about PPP, they will know, and you can apply for it. And it's a way of getting money into the law firm, and it gets forgiven, not entirely, but it gets forgiven up to a certain extent. And that certain extent is a formula about bringing people back to work or how you pay them, et cetera, et cetera. But it is possible to get a fair amount of money from the government and have a lot of that forgiven. You don't pay it back at all under the PPP loan program. And then if some of it's not forgiven, it converts into a very favorable loan, like a 1% loan that you pay back over 2 years. There's no personal guarantees, there's no prepayment penalties and all of that. So just a heads up on the PPP loan, which is keeping everyone very, very busy the last week and a half. There's been a lot of applications for that. So.
Yeah, along those lines, we've seen, different lenders have different requirements, right? So if you're with Wells Fargo, if you're with PNC, if you're with VIST, it's not a universal application per se. That we are getting different requests from different lenders, but the majority of them are working with their clients.
Right. Yeah. Go to your bank. I mean, if your bank's a current SBA lender, they'll have all the details and they'll let you know.
Yep.
But again, it's a little complicated to work through. But if it ultimately works, it's a great program. It will be certain amount of free money. Anybody who tells you that you're going to get all this money and it's all free, do not believe it. It's not all free, but it could be free in large part.
Yeah. Good. So just a couple questions, Mike, like I mentioned, that came in. One of them is, can firms decide to pay employees more than what they're otherwise entitled to under the expanded FMLA or the paid sick leave?
So two-part answer to that. Part number one, yes, you can. You can pay them more than is allowed. So if you don't want to cap it at 511 or you don't want to cap it at 20, then sure, go ahead. The second part is, I don't think you're authorized to get it back though. Mm-hmm. So you can do it. I mean, you can pay your employees as much as you want or as much as you have. Go ahead. But in terms of paying yourself back through those tax credits, those withholdings, you would not be authorized to pay yourself back at a amount greater than what the statute allows. That $511 cap for self-care and the $200 cap for the care of others.
Yep, and that gets back to those earning codes and making sure that it's classified correctly within the payroll system itself. Right. Next question, Mike, was, so given that Pennsylvania schools are now closed for the remainder of the year, If an employee wants the leave, do we give it even though we're offering everyone the chance to work remotely?
I missed the first word of that. You said because Pennsylvania schools are closed for the rest of the year?
Correct.
Yeah. Okay. Yeah. All right. So the provisions. First of all, the provisions of the FFCRA right at the moment go to the end of the year. Go to the end of the calendar year, not the school year. Calendar year, December 31st. If you've given everyone the opportunity to work from home, including somebody who's taking care of a child, and again, if the reason, and this person has work to do, and you're asking them to work from home, but they cannot because of childcare responsibilities, and yes, they would be eligible for that. I mean, everyone's getting the opportunity to work from home. That's great, but if they're not otherwise, this is meant to be a substitute for their pay in part because they're taking care of their kid. So once again, if that's the reason, then they would be eligible up to those limits that we talked about.
Yeah. So same answer. If a daycare is closed and the parents say that they need to devote time to watching their younger children who may need more guidance than those 13, 14, 15-year-olds, then that would count as well.
That would count as well. That's right. That's
Okay.
right. Again, I know the tough part of this is we're getting all sorts of calls like, wait a minute, there are two parents at home, and they have a 4-year-old. I mean, really, the person's telling me that they can't work at all, but they have a husband, they have a wife. Like, why can't they do that? And you can ask some of those questions. But when push comes to shove, if someone says, listen, I need to take care of my child, I guess you could deny it, but that's shaky ground. That's shaky ground. Just like people who fake FMLA injuries, people know they're faking, but it's sometimes difficult to demonstrate. You're guessing or you're giving your assumption. So
then just two quick last questions here, Mike. In terms of supporting documentation, right? So when this all dropped initially, I know you and I were having conversations and among our HR team here as well. What documentation should we request? Can we request any documentation? Are we going to get anything even if we do request it? As we've continued to evolve, at least I've seen guidance in terms of the audit potential on the back end of this, right? So as an employer, you're claiming such and such amount of tax credits. How do you support that then a year from now if you get audited? So I have seen some guidance in terms of what documentation employers should request and also retain. Anything on your end there that you wanted to elaborate?
I mean, other than so a couple things. Other than the general advice, which I say this for every single HR issue that ever comes up. Document. I mean, document. Doesn't have to be a 5-page report. It could be a quick email into a file or something like that. So first of all, definitely document generally what's happening. Shirley called, she asked for time off, we were giving her this amount of days, and whatever else. So that's the first thing. Second thing is, if the reason is because of a health-related reason, a medical reason, someone is told to quarantine, or they're seeking medical treatment, get a doctor's note, get a medical certification. Now, in this environment, it may not be so quick, it may not be so easy to get a medical certification. I know a lot of doctors are like, are you kidding me? You're bothering me with a medical certification when I'm, trying to deal with everything else. But yeah, get a medical certification or a doctor's note. At least get a statement from the employee, an email or something, a statement from the employee that, my doctor told me I needed to do this. So you have that for the file, and then maybe you can follow up later. And remember, for the quarantine issues, it's not that the employee self-quarantines themselves. It's not that I'm saying, I'm scared of going out. Oh my gosh, I was at the supermarket and a woman was sneezing. I'm going to quarantine myself. No, it has to be quarantine as directed by a physician. We had a lot of questions about, well, what if I, the employer, what if I, the law firm administrator, say, hey, go home, go home, Tom. We don't want to see you here. You're coughing. That's fine. Send them home. You have the right to do that. But they don't necessarily get the benefits because you sent them home. They have to be quarantined because a healthcare provider told them. And then on the child care side, same thing. At least get an email or a certification from the employee about what the situation is. And that might be the best you can do on the child care side.
Yeah, I mean, a lot of the guidance I'm giving my clients there is just, everybody's sending out emails. So it's very likely that you've got an email from the daycare, from the school, just, attach that as a supporting document.
Exactly. I mean, we have some employers who are, some businesses that are calling the daycare to verify that they're closed, which is, I mean, they're closed,
Yeah.
but right now. But you know what? Your earlier question that somebody asked, how long this goes. If this happens in the summer, if this is in July, August, September, goes into that kind of period, they may not be closed, or not.
Yep.
They may not all be closed.
Yep. Other question: if we allow the employee to work staggered hours because they have childcare issues, and the employee declines to do that, what are they entitled to? What kind of status does that put them in?
So I think I understand the question. If what we said a few minutes ago is that, first of all, the employer has to agree to staggered hours or intermittent time. So that the question sounds like, you're asking them to do that, so you agree. If you're asking them to do staggered hours and they refuse, then if you're asking them to do staggered hours and they refuse to work those staggered hours, then I would say they're not qualified for benefits. They're not eligible for benefits because the time you're asking them to work is not restricted by the child care. It's other time. The reason I'm hesitating is with this question is the only kind of fly in the ointment I can think of is if the staggered hours are after the normal work hours.
Sure.
That could be a problem. So for example, someone works 8 to 4:30 or 9 to 5, and you're saying, hey, look, I know you have to make dinner for your kids, but we want you to work at night. Normally you would have the right to ask your people to work almost any time. In this situation, I don't know how that would shake out. I suspect that if you ask people to work after normal working hours and they refuse because of childcare, I suspect that they would be right, and you would have to pay them the emergency sick time or the FMLA time.
Okay. All right, good. And then last question before we wrap up here. We talked about furloughs a little while ago, and you mentioned, furloughs usually temporary, unpaid, but still subject to benefits and other things that you have as an active employee. Does the same hold true, Mike, for policies, right? So I've had questions around, we're going to furlough an employee or a group of employees. We're worried about them going out and, bad-mouthing us in public or on Facebook, so we wanted to have them sign a non-disparagement or something like that. Are they still beholden to all of the employment policies that they were, before all of this started and before they were furloughed?
Yes, absolutely. Yes, they get the benefits of being an employee and they get the burden of being an employee. Yeah, they're still subject to that. And on that topic, I'll just expand 30 seconds, Matt, if that's okay.
Yeah.
And on that topic, I didn't get into it because there's so much to cover here. But there are a variety of considerations when someone's furloughed. For example, you probably should have some furlough guidance or a furlough policy. It doesn't have to be a formal policy, but for example, can they work somewhere else? When they're furloughed from you, can they work somewhere else? And you might say, well, sure, if they can get a job at a local supermarket and get hazard pay, then who cares? Okay, but can they work for a law firm? Can they work themselves, for another firm or a competitor, if you will? You might not want them to do that. It might interfere with them, with them coming back or being available. We've had people who have said to some of their employees, we will give you a bonus. We'll give you a return bonus or a retention bonus that, please do not go out and get another job. And if you come back, we'll pay you X. Now that's kind of in normal times when a company has to furlough for some reason and you're worried about losing your workforce. In this environment, frankly, I don't know where they're going. They might get a job at a supermarket or somewhere else that's hiring, or, there are places that are hiring. But they're not going to be able to just quit your law firm and walk down the street and join another law firm. We're all in the same boat.
Yep.
But anyway, yes, the policies do apply, and you can have them agree to things like the confidentiality or no work or non-disparagement or whatever that is.
Very good. Well, Mike, appreciate you spending a couple extra minutes here, as well as those of you who stayed on the line to see this through to the end. Hopefully you found the conversation, informative. And again, as this all continues to evolve, we'll make sure that we're putting, additional and new information out in front of you. We will make the recording available as well. But other than that, Mike, anything you wanted to add before we wrap up?
No, stay safe, stay healthy,
Yeah.
stay safe.
Absolutely. Thanks, Mike.
Thanks.
Thanks, everyone.